just to say we did contact or mention contact Mr. Richards to tell him not to come, not because we don't want to hear him, but we will have the other case tomorrow. It doesn't seem fair, since I'd said by email it'll be tomorrow, to throw everybody into a kerfuffle. So we'll finish this case and then we'll break and we'll come back for some more tomorrow.
Noted. Thank you.
Right. The Sergeant.
Thank you, my lord. I dealt before the adjournment with my arguments as to why the pure unfairness objection wasn't properly made, and so my next point is that even if the court's against me on that, in any event it wasn't a mandatory material consideration such that the Minister was under a legal obligation to consider it, and I set out my submissions on that at paragraphs 19 and 20 of my skeleton argument, so internal page 8 or page 50 of the core bundle. And my first point in 19A is that there seems to be a suggestion from the appellant that because it says it raised this argument, it thereby became a mandatory material consideration. That's obviously incorrect in my submission. There's plenty of instances, particularly in the planning context, of parties raising points that are not legally material considerations. So the test is whether it was so obviously material to the decision that it would have been irrational for the Minister not to consider it. And I just want to clarify in response to the submissions made by my learned friend this morning, I don't agree that the test is, well, if it's not frivolous, then it's a mandatory material consideration. It has to be legally relevant, as Lord Justice Holgate.
This is slightly different from an exercise of discretion. I think what Mr. Green is saying is you have an objection procedure. They have to be referred. The implication is they have to be dealt with. It's not like planning, the inspectors deciding things. It's appellate procedures. And doesn't the appellate procedure have to consider whether or not the notice should be upheld or set aside because there's no jurisdiction to serve it?
My Lord, I just don't agree that somehow the established test of obvious materiality is displaced here. There's nothing in the statute. I mean, I think the submission is that because there's the provision in respect of things being frivolous, that somehow means that that becomes the threshold and everything that surmounts that is a mandatory material consideration.
No, it's an objection that has to be referred to the committee. One talks about considerations when you're exercising discretions, whereas here it's if there's an objection and if it's not frivolous, it must go to the committee. But if Parliament has provided that an objection must be sent to the committee, surely Parliament intended the committee or the Minister, who's ultimately dealing with the objection, to decide whether to uphold it or not to uphold it.
Well, I suppose, my Lord, the position doesn't seem to me to be different to the planning context, where if someone raises a point, I don't know, the impact on the value of their house, it's not legally a material consideration, but probably the decision maker still has to read what's said. It doesn't mean that then legally they're obliged to turn their mind to it beyond that.
So I object, and I say there are 6 reasons why I don't want this notice to be given. And the Minister can just say, well, I'm upholding the notice. Doesn't have to say anything at all. Doesn't have to do more than read them.
Well, my Lord, in my submission, yes, because there are instances in the planning context where there are consultation duties and duties to consider consultation responses so as to read them, but that doesn't mean that everything that's said in the body of those responses is then a material consideration.
Well, this isn't planning, this is forestry. And this is a situation where somebody is believed to have committed an offence and they're being required to expend money and do things, and they're given the right to object, but you say the same principle applies?
My Lord, yes, I do. And as I set out at 19C, the Secretary of State doesn't accept that this sort of softer argument around unfairness was so obviously material as to be a mandatory consideration because...
Sorry, just before we go on, to make sure I haven't misunderstood what you're saying. Earlier in your submissions, you say you accept there was a failure on the part of the Minister in terms of giving reasons. I think you've made that point, but do you say that relates to the proper abuse argument?
My lady, yes.
Not this,
My
even
lady.
if this was articulated.
My primary submission is that the only argument that was properly articulated was the legal abuse of power
Yeah.
objection.
Okay, and it's accepted that the minister should have dealt with that.
My lady, yes.
I mean, you could have a situation, looking at it in a broader public law way, where a matter has not been raised by an objector, but as a matter of law, the court would treat it as an obviously material consideration, and then that would have to be dealt with by the decision maker, whether it had been raised by a party or no.
Quite, my lord. And part of the reason why my submission, this soft of unfairness argument, wasn't so obviously material here is that the minister was obviously under a duty not to be so unfair as to be unlawful. And so in that context, I submit that there's simply not room for the additionally to argue that there's a sort of lower standard of unfairness that pushed its way into the decision-making process as another thing that had to be taken into account. And my learned friend refers to the need for there to be safeguards and for the appeal process to be one of those. But in my submission, the established public law principles provide perfectly adequate safeguards. If the minister had gone wrong in a public law sense or acted in a way that was Wednesbury irrational or was so unfair as to be an abuse of power, then obviously the appellant would have had means of redress, and so would anybody else. And at paragraph 20, I articulated what I think is the point that was mentioned earlier about all roads leading to Rome. I mean, it does remain the Secretary of State's view that the appellant hasn't succeeded in articulating how there is a separate, lesser standard of unfairness that was somehow a material consideration here.
By the way, we're looking at section 17, capital B, page 32 of the authorities. A person on whom a section 17A notice has been served who objects may by notice within the prescribed manner. That sounds as if there are regulations which set out how a notice of objection may be. Is there anything we ought to know which is relevant in the regulations dealing with the prescribed manner?
My Lord, not that I'm aware of. I didn't check what I believe
Thank
to
you.
be the prescribed regulations. And
Thank you very much.
Say anything. I will double check that though, just to make sure that I'm not saying anything misleading.
And then what happens under 17B1 is that someone who puts in an objection in the prescribed manner and the prescribed time, that matter, it's the matter which is referred to a committee. And then grounds are referred to, so the minister shall, unless of the opinion that the grounds are frivolous, with maybe one ground, refer the matter accordingly.
And the final point I wanted to make on this softer unfairness argument.
The other problem too is I'm just looking for the matters referred to the committee, and then you get to 27(3) on any reference being made to them under this part of this Act, and assuming for the moment that it did include this generally inappropriate to require them to do this ground. On any reference, a committee appointed according to this section shall afford to the person concerned an opportunity of appearing before them and of making representations to them on the matter in question. So I wonder again whether this is really more to do with quasi-judicial type processes rather than exercises of discretion. What's the point of saying they've got to hear representations on the grounds if they can just be ignored if they are immaterial not material considerations?
Well, I don't think I can improve
Add anything
on my
further, you
previous
just say it
response
is.
on that, my Lord.
Yeah.
But I mean, I do wish to emphasise this isn't my primary
No,
point.
your primary
My
submission is
point the one I've
that it
got.
was just a legal objection. Yeah.
Um,
So is that ground one then?
Not quite, my Lord,
not
but
quite,
very
okay.
nearly, if I may. Just to note that even if this softer unfairness argument was a material consideration, given the sort of gentle manner in which it was presented, if indeed it was at all in the documents, I don't accept that it was a material consideration that reasons were required in relation to. This is the South Buxton Porter point that was raised before lunch. So I don't accept that it assumed such importance in the overall scheme of things that the Minister would have had to include it in her reasons, because it wasn't put to her as squarely as the legal abuse of power objections. On ground one, my Lord, I have two further topics, both of which I hope I can deal with quite shortly. The first is just to make very clear the Secretary of State's position on parliamentary privilege and just clear up something that I may not have articulated properly before lunch. And then I just want to address the court very briefly on Bradbury and section 31.
Oh, yes.
So on parliamentary privilege, I'm slightly concerned that in my enthusiasm to respond to the appellant's point, I might have sowed some confusion as to the Secretary of State's position. The reason that I dealt with it is because the appellant in the skeleton argument criticises Mrs Justice Lieven for having, he says, applied the principles that regulate when the court can look at documents to the Minister. And I don't accept that that's what she's done, because if we need to turn this up, obviously we can do, but in paragraph 149 of the judgment, well, actually it may help if we do just briefly turn that back up. So if we could go to paragraph 83 of the judgment first, please, which is page 88. You'll see that what the judge says there is there's a dispute as to whether the report can be relied upon and referred to in this court, and that was the Secretary of State's concern. And then at 149, which is page 103, this is the judge considering section 31. So in my submission, what she's doing here is considering for herself whether this abuse of power objection has any legs or not, and in doing so she is directing her mind to whether she is entitled to look at the report or not, and that's where principles in Spaff Homes and Heathrow Hub come in. So really the reason why I've gone to that is just to resist any suggestion that the judge has somehow erred in what she's done at paragraph 149. It has consistently been the Secretary of State's position that the report is not admissible, both before the High Court and in this court, and that remains our position. From, I think, the pertinent reference is probably even in our summary grounds, this is page, I won't go there, but in page 187, we've set out why we consider that none of the sort of exceptions in which the court can be referring to the report are engaged. So I just wanted to make perfectly clear that I'm not suggesting this court should be looking at that report, and indeed we have consistently opposed
Can we look at it for the very limited purpose of it happens to be the only document to hand which allegedly records an assurance that was given? Can we look at it for that purpose as a source of information?
The reason that I think that's still uncomfortable, and I appreciate that I'm not standing before you saying, well, what was said, that's not an accurate record of what the Commission said. But the reality is nobody seems to, and we have tried, nobody seems to actually be able to access the origin of the quote. And so it seems to me to be difficult for the court to even go that far without potentially depriving the Secretary of State of the ability to say, well, hang on, is that accurate or not? I mean...
But the principles of parliamentary privilege were revisited by the Divisional Court last Friday in ARL. Am I right in recalling that the privilege, if it applies, extends to not merely things said, for example, by MPs and ministers, but also by witnesses who provide evidence in parliamentary proceedings?
I mean, I haven't looked at that authority.
Because if that is right, even if we found the source, if there is an objection in terms of privilege, it would apply to that.
I mean, that aligns certainly with Spaff Home, which I haven't gone to, but that says very clearly that certainly beyond what is said by a minister to Parliament, you know...
Well, Lord Reid says something similar in SC, I think.
Yeah. So...
Well, SC is again slightly different. SC, he says you can take account when assessing proportionality in the context
No,
of a
yes.
convention right of the fact that an issue was raised in Parliament, because that then shows that Parliament has considered the issue. He then goes on very carefully to say that you mustn't start assessing the quality of what was said. But I think there is an issue here, and I'm concerned that it's not been properly researched, that we've moved from this can't be used for interpretation to it appears to be the source of an assurance. And then we're into questions as to has the committee adequately recorded it or not. But I think there is authority, as my Lord has indicated, that evidence to committees may be covered by parliamentary privilege, and we shouldn't be here discussing this now. I mean, either we can refer to this as a record of an assurance given, or we can't. So which is it?
My Lord, might I just...
This shows why things should be referred to speakers.
Yes.
Yeah. We previously, and I had understood the debate to have subsided slightly, which is why it's not before the court now, but our position previously was that in reliance on OGC, where evidence is contentious, then it can't be referred to. We haven't got the OGC case in
I know.
today.
This is contentious because there's a huge issue as to what it means, and was it all that was said?
Yes, I mean that is essentially the Secretary of State's position, and the reason why we are concerned about this and have made the points that we've made is that it's a record of what the Forestry Commission is alleged to have said, and as I said, we haven't been able to disprove that it's an accurate record, but there's a question mark, it seems to me, over whether it is or whether it isn't, and in any event.
And just so I'm clear in my mind, is your submission that Mr. Green is or is not allowed to rely on this report as a source of information of an alleged statement by the Forestry Commission?
Not. My submission is that it's not before this court. The debate, I think, is did those principles apply to the minister, but it seems to me that we've just travelled past that, because I asked the court below, and I am now asking this court to reach its own view on the merit of the legal argument that Mr. Green was pursuing.
Yeah. So that was the parliamentary privilege part. You said there was another...
Yes, forgive me, my lord. Yes, I just wish to draw the court's attention. This is Spaff Home, so it's tab 11 in the authorities bundle.
Yeah.
Internal page 227.
Yeah.
And then at G, your lordship will see that Lord Bingham says it's one thing to rely on a statement by a responsible minister or promoter as to the meaning or effect of a provision in a bill, thereafter accepted without amendment, but it's quite another to rely on a statement made by anyone else.
Yeah, that's in the context of using Hansard as an aid to interpretation. And that's part of the rule which limits Pepper and Hart to the promoter of the bill.
My lord, yes. My simple point is that having regard to particularly Heathrow Hub, which enumerated the other circumstances in which regard can be had, I say that the appellant is not within any of those, and it shouldn't be relying on the assurance by the Forestry Commission in front of this court. So that is parliamentary privilege. And then finally on ground one, Bradbury. So if we could turn to paragraph 148 of the judgment below, which is at page 103.
Yeah.
And obviously the judge there refers to Carver Bien, understandably, because at that point in time all the parties were agreed that that was an appropriate approach and we put it in front of her. But then all that she says is that it's a high hurdle whereby the court conducts its own assessment, and I don't really read that as indicating one way or another whether the judge has sort of trespassed into a prediction, which is not appropriate, or whether she just means an assessment in the sense of taking the error out of the equation and just following the logic through of how...
But that's what you can't do, according to Bradbury. The one thing it says that you shouldn't be doing is guessing or speculating as to what a decision maker would have done.
My lord, I accept that, but as I read Bradbury, and I'm obviously entirely happy to be corrected, but as I read it, it's permissible to assess and required, because of Section 31 requires the court to undertake some form of exercise, it is required to assess the impact of the error and ascertain whether the conditions are met. So I don't see anything in paragraph 148 that indicates that the judge has gone wrong and gone into prediction territory rather than just assessing the impact of the error.
But classically, you do that, as I understand it, by looking at the impact on the error on what was done, what was said. Otherwise, the court, and this is where cover BN was causing problems, is being invited to supplement, to supply missing reasoning and acting as a fact finder, a decision maker.
I think the only reason I hesitated is that in Bradbury itself, as I recall, there was a draft report which hadn't been taken into account, but then when regard was had to it, actually, it just sort of said everything that...
Well, the facts were that they were supposed to have regard to an assessment carried out by a particular person, and they didn't have the assessment. What they actually did, without the assessment, was grant planning permission with certain conditions attached. When the report finally emerged from the person who was responsible for producing it, as it happened, that person said, yes, you can grant planning permission provided you attach these conditions. And the conditions happened to be materially identical to the ones concerned. So you knew that even if the decision maker had not committed the error, and even if it had had the report before it reached its decision, what it would have done is do what it did, which was to grant the planning permission subject to the conditions. But this will be a different situation if there's a sort of general inappropriateness because it's too harsh to enforce it. We don't know what the minister would have decided to do on that, do we?
Sorry, I've caught up with my lord. I accept that on the softer-edged general unfairness point, if all of my other points are unsuccessful, then it is difficult for me to argue that we know what the minister's response to that point would have been. But for the reasons I've already explained, I don't agree that we ever get there. And then the other two sort of angles on Section 31, I mean, as I began with this morning, in my submission, the legal error identified here, or the behaviour, the conduct, is a failure to give reasons, and we do know what the minister's take on this, on the legal abuse of power objection was, because we know she didn't accept it, otherwise the appeal would have been allowed. If I'm wrong about that, and the court prefers the view that the minister didn't even take into account the hard-edged legal abuse of power argument, then I don't dispute, as I said before lunch, I don't dispute that the minister should have taken a preliminary view on that, but I agree that the ultimate question for this court now is, was there a legal impediment? And in my submission, the answer to that is no, looking at the statute.
Yeah.
And so Section 31 applies, so that relief should be refused.
Yep.
My lord, that is the end of ground one, unless there are any queries.
So ground two?
Ground two, there is relatively little, I think, that I need to add to what I've said in my skeleton argument, but I do just want to emphasise at the outset that the Secretary of State's position is that the threshold of review is Wensbury rationality here, so it wasn't for the High Court and it's not for this court to reach its own view as to whether what the minister did was proportional or not. The question is, was the approach, so wrong as to be irrational in the Wensbury sense? The point that I do just want to go back and pick up on the papers actually is the plan that we looked at briefly before lunch, which is
Page 82 of the supplementary bundle, yeah?
yes. Just to point out that when we're looking here at the red outlines, so there's a a bit difficult, but there's a group at the bottom which is TG1, I think, that covers the entire width of the bottom of the site or the area in question. Then there's T4, then there's TG5 above and to the right of that, which is another group. And then we've got T21, T22, TG3, TG4, those are two groups. And then T26, and in the top right hand corner are TG2. So the short point is that when we look at what is the extent, the red lines demarcate the extent of the tree canopy, we can see from the key. Actually, the trees that were felled cover a significant proportion of the site. And this is the appellant's document and forms part of the case that the appellant put before the reference committee. And I respectfully invite the court to ignore whatever the arboriculturist is alleged to have said afterwards, because it's not supported by any documents.
You get some help at page 75, which describes the scope of the assessment and refers to a plan 6995402, which seems to be what we've got at 82, unless anyone says otherwise, but it describes the entire woodland parcel, trees T1 to T27, and then the woodland group features TG1 to 5.
My lord, as I understand it, the plan that we've just looked at is the plan that's being referred to here. And I don't accept that that the approach that the reference committee and then the minister took discloses a sort of absence of factual link between the harm caused by the offence and the remedy that has been required of the appellant, because it has only been asked to restock the land where the felling took place. As my lady pointed out, the appellant is not arguing that somehow the boundary and the line drawn around the area is wrong. And I was going to make the point, and I will do anyway, but Lord Justice Holgate had read to it before lunch. It would at least arguably be more disproportionate, if not impossible, to require the appellant to approach this on a sort of one-for-one replacement basis, because what was removed was mature trees, that appears to be common ground, and groups of trees, which it seems to me are likely to be far more costly than the £500 that was required for the widths that we've asked for. And just one final reference in the papers. So I've referred to page 145 of the supplementary bundle.
So 145,
145.
yes, I got it, sorry.
Yep.
And the bottom half of that page is where we find Mr. Murdoch, so Forest Services, the Forestry Commission's explanation of essentially why they've gone with the approach that they've gone for. But just to add to that, at page 100, you'll see there's a heading claim 4. This is the Forestry Commission's rebuttal that it produced before the reference committee. And then you have the Commission's rebuttal to this argument around, is it grossly disproportionate? And I refer to that simply because it's essentially the same points, but around how this is the standard for restocking, and why, when we're talking about widths, actually, although the figure of 242 might seem high, in reality there's nothing untoward about it.
Are you looking at the bottom paragraph then?
My lord, yes, under the heading FC rebuttal to 4.
The woodland is much more than.
Yes, and then it carries on over the page. Essentially, the rest of that reasoning down to where it says claim 5 is what I rely on. So in a nutshell, not irrational in the Wensby sense, even if the review threshold were proportionality instead, it's not disproportionate either, and the reference committee turned its mind to proportionality and reached the conclusion that it was proportionate. Unless I can assist.
That's very helpful. Thank you very, very much, Ms. Sargent. Green.
My Lord, ground one. It suggested that the Minister reached a decision on the first objection, but just didn't provide reasons for her decision. That doesn't appear with respect to how Mrs. Justice Lieven approached the matter. If one looks at the judgment in the court bundle, paragraph 149, in my view, the section 31.2a test is made out because the abusive process argument which the Minister failed to address is wrong. And at the bottom of the page, 152, Mr. Green submits that the error was that the Minister did not deal with the argument rather than that it would necessarily have succeeded. However, in my view, the reason set out, I think it is at least highly likely that the Minister would have rejected the argument and upheld the RSM in any event.
We go 141 to 144. It looks as if the judge below actually avoided deciding whether it was reasons or failure to address, and said whichever it was, there had to be reasons.
Yes.
Yeah.
But secondly, whatever Mrs. Justice Lieven's view on that was, if one looks at the documents that were put before the Minister, they create a very confusing picture, and not one from which one can readily say, well, her decision must have been X or Y. One had the reference committee's report, which says, paragraph 1, we're not dealing with this. And one has the submission to the Minister from the Secretary to the Reference Committee saying, in essence, you can rely on the Forestry Commission to act lawfully. And it's entirely possible that the Minister agreed with the Reference Committee that this was out with her jurisdiction, or agreed with the submission from the Secretary that she could simply assume that the Forestry Commission acted lawfully. Even if one accepts that she read all that was sent to her, one cannot draw any conclusions as to whether or not she reached a view on that material, or what view that was.
Yes.
My Lord, at 148, it's plain that Mrs. Justice Lieven did base her approach to section 31.2a on Carver bien,
Yeah.
and that colours, in my respect, the Commission, the entirety of 148 to 152. Understandable at the time, as was said, it was an agreed position of the parties, shown now to be wrong. So far as parliamentary privilege is concerned, I haven't gone into that in any great detail because, of course, the Reform Committee's report was relied on in objections to the Minister. The point is, the Minister is not acting as a court, and for the reasons I've given in my skeleton argument, parliamentary privilege is concerned principally with what courts can do with parliamentary material. So accepting that the report is parliamentary material and that the evidence of witnesses is parliamentary material, the fact is the objector, the appellant, was relying on it in its submissions to the Minister, and in that capacity parliamentary privilege simply doesn't apply. And the question for this court is a second-hand question. Did the minister lawfully address that material? In the course of this hearing, all sorts of concerns have been expressed about using the material and understanding it and its provenance and so on. And my lord, I understand all of that. And those are points that the minister, if they were relevant, should have taken on board. They're not points that this court has to resolve at all. The question for this court is, did the minister lawfully address this objection given the material supplied to her? That's all.
Say the matter, for the sake of argument, goes back to the minister for redetermination in the way you've just suggested. That wouldn't necessarily be an end of the matter. There could be a further challenge by way of judicial review by whichever party failed. And that would raise squarely the Parliament in the court, the parliamentary privilege issue.
It might do, my lord, but in my respectful submission, it's not raised in this hearing.
But it's always going to become relevant to the court, because if there's a challenge to the failure to decide it or to the decision that's taken, that can be the subject of challenge. And in deciding, say it's the failure to address, if there's no, if legally there was no such assurance given, then the challenge would fail, whether you call it discretion, remedies, no legal error, and so on. But at the end of the day, somebody's going to have to decide whether a decision saying yea or nay to the issuing of a notice based on the matters in the report is a correct reading of the report. You can't really get away from that, can you?
Well, all I would say is that it should have gone to the minister. The minister should have tackled it. And the report itself was not put before the minister, unfortunately, nor were the relevant extracts put
But
before
why should it be? I mean, you're the objector. If you're saying that the report should have been put, you should have put it.
Why not? We put it before the
Oh,
committee.
you put it before the committee, but they didn't send it on.
wasn't
Right,
tried,
okay.
yes. So we tried,
You did try.
and unfortunately that material did not make its way to the minister. All the minister had was the reference committee's summary of my submissions and the report itself from the committee, but neither of those sets out in any detail what was said in the Regulatory Reform Committee's report. So the minister didn't have any of that material. And before this court explores too far the concerns that might arise, we simply say it should go to the minister can reach her decision, and it's only if there is a further challenge that these potential concerns need to be considered.
Yeah.
A minor, very discreet point, paragraph 150 of the judgment, reflecting also what's said at paragraph 85 of the judgment, it is said that I relied on SPARF home. I didn't. A simple error of fact. It was in my learned friend's skeleton argument, not mine. It was my learned friend who dealt with those submissions, not me.
I wish to check this actually, if I may.
I can provide the references if that helps. And I'm perfectly happy to be corrected, but having gone through the transcript and the skeleton arguments, I did not rely on it. I responded to one question from Mrs. Justice Lieven on it, but it was raised by my learned friend as an authority and dealt with at length in her submissions, not mine. And I didn't rely on it for the simple reason that, as my Lord Justice Holgate indicated, it's concerned with the interpretation of statutes using statements in part.
Except that when you read the judgment, when earlier on, I can't find it at the moment, the judge attributes reliance.
85, I think.
Sorry?
85.
85, thank you. It's in the context of assurances.
My Lord, yes, because there is a passage where Lord Bingham refers to the the possibility of a minister giving a complete categorical assurance as to how a power will be exercised, and that might, in those circumstances, colour the interpretation of that power. But my Lord, I simply wasn't relying on it. And I'm quite happy to be corrected by my learned friend if that's wrong.
But don't worry, we know you're not relying on it in this court.
No, I'm certainly not relying on it
remember
in this court,
not to get into this.
No, it's a minor point. I don't raise it in this appeal. It doesn't matter. Yes, material considerations. It's a very short point. My learned friend says there's a test. Is something so obviously material? It's only if it is that it needs to be taken into account. Well, that's part of the tripartite test. The statute requires that it is taken into account or isn't taken into account, or is there one of these intermediate considerations which might be? Given the statutory scheme, an objection is a mandatory material consideration. The Act requires that it be considered by the Minister and the Reference Committee. It's as simple as that.
I wonder whether it's material consideration language exercise at all. It is an objection
Yes.
which has to be addressed.
Yes, it's as simple as that. Yes. Well, that's all I propose to say on ground one. Regarding ground two, I would enter this note of caution in relation to the plan that was referred to. That forms part of the woodland management plan, which begins at page 72 of the supplementary bundle.
Yeah.
Dated the 27th of June 2017, so some months before felling took place. Its purpose is to show what was intended at that time to be done. It is not a record of what felling in fact took place.
No, but we know what they were up to. They wanted to fell these trees and these fruits. That's what they did. Or they would need to fell these trees and these fruits.
Yes, but the felling was interrupted because a neighbour saw what was going on, told the Forestry Commission, and they intervened. But the figure of 9 comes from the arboricultural consultant who compared what he saw on site with this plan, which is a detailed tree survey.
I think because we're obsessive, we would need to see something which constitutes evidence to that effect. And there isn't, as I understand it.
Not before the court. No.
No.
But my Lord, I believe I've made all my other submissions on ground. So unless there's anything else.
No, well, that's very, very helpful. Thank you very, very much. So, since there's technically two separate cases, we will obviously not be giving a decision today for two reasons. One, we want to think very carefully and read all the material in the cases that you referred to. And secondly, we will hear the other cases as well because they're linked. In due course, we will issue a judgment either in this case or two separate judgments. Could be either. And we will follow the usual pattern where we'll send a draft to council. The purpose of that is just to correct any factual errors or any obvious typographical errors, not to re-argue the case. We've had the argument. And that draft is confidential. And should it be disclosed or referred to, that is contempt and can lead to very serious consequences, actually. So when you get the draft, I'm afraid to say you have to treat it with the utmost care and make sure that you treat it confidentially. And then there'll be a few days for you to put in your submissions and a draft order, because by then you'll know who's likely to win. And then the judgment or judgments will be handed down electronically. You don't need to come back to court. It'll be done over the internet, as virtually all of life is these days. And the order will be made, and that will be the end of it. But in the meantime, thank you all very, very much, both council and the teams behind, and to everybody who's been listening to what has been an interesting case. I've learned more about trees than I realised. More than to them than meets the eye. So we'll see some of you. I don't know whether all of you are coming tomorrow.
That's why I rose.
Yes.
That's whether it would assist the court for myself and Mr. Green to attend tomorrow, or whether you're happy that.
Well, we've got Mr. we've got, yes, Mr. Simmons or Simons?
It's Simon's,
Simon.
my lord. I'll be here for the... Yes, I'll be here tomorrow.
Right. And you're the appellant, of course.
I'm the
yes,
appellant
in
for
that
tomorrow,
case.
that's
So,
right.
right, okay. No, well, it's very kind of you to offer to stay, but I don't think we require you. But if you do wish to come, it'll be a delight as always to see you. Okay, so we'll see those of you who are going to come for round 2. We'll see you tomorrow morning.
Thank you.
All rise, people.